Good evening, everyone. It is just struck past 5 o'clock. My name is Jed Horner, and I would really like to welcome you to tonight's launch of the Australian Society for Computers and Law. We're thrilled to have so many people online this evening, joining us from all around the world and not just within Australia. On behalf of those present, I would like to acknowledge and all First Nations peoples and pay my respects to elders past and present, on whose land we meet for today's live event. And for me here in Sydney, windy and cold Sydney I might add, but glorious Sydney nonetheless, that is the Gadigal people of the Eora Nation. For our guests from across the Tasman and in Aotearoa, New Zealand, ina iwi o Aotearoa, rauranga tira mā, tēnei te mahi kia koutou I runga I te kaupapa o te rā. I also want to specifically acknowledge those members of the judiciary, both past and present, as well as current or former members of our parliaments who might be joining us this evening. And on that note, if you are joining us online and you want to join the conversation, you want to get involved, and you want to be part of this exciting dialogue, I encourage you to join our discussion on Slido. The details are very straightforward. If you have your smartphone, your computer in front of you, quite easy to join this discussion. All you simply need to do is type in the browser page right in front of you, sli.do, that's sli.do, and bring up the browser. And then enter the event code. The event code's in front of you, it's a QR code, but it's also hashtag AUSCL, that's Australian Society for Computers and the Law. And that means you can join our conversation when we have our dynamic panel later on, and throughout the speakers we have joining us this evening globally. And without further ado, I do want to hand over now to Marina Yastaboff, who is, of course, the national convener for the Australian Society, to speak further about the vision and all the exciting events that are planned. Marina, without further ado, I'm handing over to you.
Fabulous, and a nice rhyme there at the end, Jed. Thank you so much for emceeing tonight. Good evening, everybody, distinguished guests, colleagues, friends from across the world. Welcome to this historic occasion. The Australian Society for Computers and the Law, while we're new, we actually stand on the shoulders of giants, such as the Honourable Justice Michael Kirby, Julian Burnside, and Professor Greenleaf, all of whom will be speaking this evening. The Society is an Australian registered charity with the mission to advance education and advocacy at the intersection of law, technology and society. We are proud members of the International Federation of Computer and Law Associations who are also joining us this evening. I'd like to share with you our advisory board and to introduce you to their members. You would see on the screen there the full advisory board. It comprises of exceptional leaders in academia, community legal centres, business and the technology industry. We're honoured to have them advise us as we go on this journey. We're also honoured to have the support of many leading law firms, visionary NGOs, government departments, associations and interest groups. And we're sharing those with you on the screen now as well. There are too many to mention, but thank you all to our generous supporters, and we look forward to cooperating with you to collaborate on projects in the future. Thank you for supporting this wonderful event. I'd also like to thank those on the screen here, because an event like this really doesn't happen without the support of many. And while we will be having a vote of thanks at the end, I did want to mention them up front, especially wonderful Ashley Lewis, who is behind the camera now, making sure that the slides appear at just the right time. Thank you, Ashley. Fantastic job there. We're delighted you could join us today from across Australia, New Zealand, Oxford, Geneva, and as far away as California. Thank you for joining us. Enjoy and celebrate with us. Now back to you, Jed.
So I've just unmuted myself, and thank you so much, Marina, for that exciting introduction. I now want to call upon Associate Professor Peter Domkins, PwC Future Law, and obviously has a range of appointments, too long for me to recite now, to talk about the exciting launch of the journal. Peter, all over to you.
Thank you very much, Jed. So if we could just move to the next slide. And following on from Marina's introduction, I note that the journal for the Australian and New Zealand Societies for Computers and the Law, first published in 1983, and in its 1984 edition stated, and I quote, representatives from societies for computers and the law in New South Wales, Victoria, Queensland and Western Australia met at the home of Julian Burnside in Melbourne to discuss matters of common interest, including the publication of the first issue of this newsletter and the feasibility of establishing a national society for computers and the law. So it's wonderful to be able to see such continuity of purpose and vision in what we're doing today. We've got some numbers up on screen and I can talk to you what they mean. As you can see, as I mentioned, it was first published in 1983. Since then, we've had 38 years of publication, including 37 years of continuous publication. We've had 776 articles. We've had 924 contributors. In our most prolific year, it was a tight competition, but it ended up being 1996, where we had 57 individual articles. According to AUSCL, where the journal is located and searchable, we've had over 120,000 accesses of the journal within the past 12 months. And the most prolific contributors were the editors. We've got on screen a selection of some of the top searched for articles, or the top ranking journal articles, including from, no doubt, some people that are on this call this evening, including Philip Argy. If we move to the next slide, thank you. Where I'll have listed. So we have our mentioned the contributions of the editors previously. There's 28 of them as listed there, and we've got proud to present our 2020 editorial board, including myself, Delvin Chen, Dr. Natalie Stonoff, Jacob Lancaster, and Thomas Kemery. We do have a call for submissions for this year. It's been sent as part of the invitation, and we will be making it available elsewhere as well. The deadline is the 30th of September. We're calling for a wide range of submissions relating to contemporary legal issues and technical developments, including areas such as AI, ethics, e-civility, future democracy, e-voting, future money, future cities, IoT, big data, future medicine, epidemics, very timely, quantum computing, and that's by no means an exhaustive list. So please, as the call submissions is now live, and we highly encourage you to make a contribution. That's me. Back to you, Jed.
Thank you so much, Peter. Appreciate that. And look, you touched on a few exciting topics, which I know we're going to talk about later this evening, all future focused too. So I'm sure that excites people. Just a reminder to everyone joining us via Slido, do start banking up your questions now and engagement. We want to keep you online during this event. Noting we're going to have panels very shortly. A live cross thing one would do on TV and jump straight ahead to Justice Kirby, someone who probably doesn't need an introduction to most of our Australians on the line, or indeed people internationally. And for those who don't know, I will recite a brief background. Obviously, been on the bench of the High Court and has served extensively internationally as well in relation to North Korea, where he's delivered some incisive reports which have held abusers of human rights to account. And I personally know Justice Kirby has had long involvement on issues including HIV, which is, I think, how we first encountered one another many years ago. So thank you, Justice Kirby, for joining us this evening.
Well, thank you very much for that introduction, and I'm sorry to be holding up Professor Susskind, but I will stick to my allotted time, but begin by paying my respects to the Indigenous people right across this continental land. It's not only the land on which we stand, but in the air and in the ether and in the digital space. The Aboriginal people have suffered many injustices in the law, and that should be one of the issues that is addressed by the new society. I also recognise the Indigenous people of other lands, Tēnā koutou, tēnā koutou, tēnā koutou katoa. And I recognise everybody who is on this call, including my old friends, Julian Burnside, QC, Graham Greenleaf, Francis Gurry, Ginni Patterson, and all of you who have come together for the purpose of the launch of the Australian Society of Computers and the Law. Well, why am I here? I'm here basically because in 1978 to 1980, I had a most interesting task with the OECD in Paris. It arose out of events which are much in the mind of Australians today, with the revelation of the so-called palace letters concerning the dismissal by the then Governor General Sir John Kerr of Prime Minister Whitlam and his replacement by Prime Minister Fraser. Mr. Fraser promised that if his government were returned to office, he would give the Law Reform Commission, of which I was then the chair, a reference on privacy protection. And that reference was duly given, and it led to my being sent to Paris to the OECD, chairing the OECD expert group, working with the most brilliant team of people I've ever had to work with, and that includes some of the judges I've had to work with, and coming forward with the OECD guidelines on privacy protection in the context of transborder data flows. Those guidelines have proved very influential, not only in Australia, where they formed the foundation of the Australian privacy principles in the Privacy Act of 1988, but also in many other countries with different legal systems. I think it can fairly be said that the OECD privacy guidelines were extremely influential in the basic conceptual principles that would guide the international community at the outset of trying to devise the concepts and the principles that would govern the regulation of computers and the protection of basic human rights, including the right to privacy. There was one fundamental problem with those principles, and it was revealed as the technology advanced, because the technology sure didn't stop still in 1980 when the principles were adopted by the Council of the OECD. And that was a principle that governed the control by the individual or by society in the use that would be made of data that was collected. And the principle said that data that was collected should be used only for the purposes for which they've been collected, known to and approved by the data subject, or as provided by law. And the problem with that principle, which was fair enough at the time that it was adopted by the expert group, was that along came the search engines, Google and Yahoo and others, and those engines could use data and search data most efficiently for purposes other than purposes that the data subject had consented to and knew about, or other than those that had been specifically provided by law. And therefore, one of the core principles of the OECD guidelines was not really appropriate to the technology as it developed. And that laid a challenge before the community of scholars and officials to try to devise new principles and principles appropriate to the technology as it was developing. And unfortunately, in the meetings that were held in the OECD and outside, it became very difficult to agree on any change to the guidelines of 1980. Later, the Council of Europe, the European Commission of the EU developed its own principles, and in particular, the principles that are contained in the General Data Protection Regulation of 2016, came into force in 2018. And that principle, that set of principles, has now effectively become a core set of principles for the regulation of privacy and many other social issues that are presented by the information technology. And this is why you can't stand still in the work of a body such as the Australian Society of Computers and the Law. The technology continues to change, and that technology requires the best minds to address the social issues and to lay out the principles that will guide democratic legislatures and the executive governments. And that is why this is such an important event tonight, because the Australian Society of Computers and the Law will provide a voice for the international community and for Australia on these issues. In fact, an article by Greenleaf, which has described the explosion of data protection laws, is a very interesting exercise in the explosion of law in this field. He points out that just in the field of data protection laws, and not to embark upon all those other areas that Peter Donkins has mentioned in the introduction, that in that area, what began with just a few laws of the Nordic countries in the 1960s, the law of the state of Hesse in the Federal German Republic in 1970, has expanded enormously, so that by 2019, 132 countries had such laws, and it's anticipated that by the end of the 2020s, 200 countries will have laws in the field of data protection. And this is a very great increase in and expansion of the treatment of information technology, and in particular in the area of data protection throughout the world. And the EU GDPR principles have been extremely influential in many countries, and they have become the standard against which you have to measure your own national principles and laws. And as Greenleaf has pointed out, when we now measure the Australian Privacy Act against the standard of the European regulation, unfortunately, there's a lot wanting, and it'll be an important function of this society to call those deficiencies to attention and to ensure that the government and successive governments maintain the momentum of providing in Australia and elsewhere the respect for the principles as they are developed and as they deal with entirely new problems. That there are new problems is demonstrated by the work that has been done in the area of the undesirable social developments that have been called to notice by Professor Zuboff in her work, The Age of Surveillance Capitalism. She has described the fight for protecting the individual against what she calls a new frontier of power, and the need for ensuring that the internet, originally conceived as a liberating element for humanity, will remain a liberating facility. I found in my work on North Korea that is one country where citizens, except those in the elite, cannot get access to the internet. And you realize in such a country the limitations that imposes. But on the other hand, the developments since the year 2000 have illustrated the way in which surveillance technology and marketing have come together to have an enormous impact upon the freedoms of the individual, and that has required a response by society to take away the capacity of capitalism, capital, to predict the decisions of individuals and the propensities of individuals so as to trap them in a course that may not be in their interest and that they may not, if they were informed, really want. The remedies there will be very important, and the remedies will need to be suggested and developed by bodies such as our society. They have to be global because nothing else will really work, but global remedies, as we're finding with COVID-19, have to begin with national and local responses. And the age of multilateralism is by no means over, as is demonstrated by the challenge that we now face with the pandemic that we're facing throughout the world. Now, that pandemic has also demonstrated the kind of issue which can illustrate the values of information technology, but also the dangers. In Australia, as we Australians know, the COVID Safe app was developed, and in fact it was released 2 weeks before a piece of legislation was enacted within a space of 2 days by the Australian Parliament on the 14th of May 2020. That legislation was immediately gave effect to the use of the COVID Safe app, which had been installed by 5.5 million Australians. That was 25% of those having a mobile phone. That has led to the endeavour to turn the technology to the battle against COVID-19 virus. In fact, in the space of 1 month, only one extra case was revealed by the technology, and looking back, it does seem that the hopes or expectations that there would be an enormous value in the technology have not really been borne out. But on the other hand, the way in which the Australian Parliament approached the matter did appear to show a great sensitivity to the issues of voluntariness, of involving the data subject, making sure that there was truth in government in revealing what was said to be the value of the app, and ensuring that the data subject could delete the data, and that the pursuit of the issue by contact tracers would be decentralized and not further evidence of the kind of centralized supervision of society that has caused such anxiety on the part of citizens in several countries, including, as we've seen recently, in Hong Kong. And so that, I think, is a very recent illustration of the fact that the data and the capacity of the data to be useful have to be looked at with a very practical eye by a government and by those who have the power over the technology and also over the regulation of it. I have to add that it's important that this society should address the issues of data protection laws in Australia, of the control of technology, of the protection of citizens against the dystopian nightmare that was suggested by Professor Zuboff, and being sensitive to the capacity of technology, the desire for it, but also the regulation of it, is something which I believe this society is going to be very well adapted to doing. In the latest part of the LexisNexis Privacy Bulletin, there is an excellent article by Mr. Leonard, and that article suggests that the fundamental problem that we face in Australia with computers and the law is that our legal regulation in the Privacy Act has simply not kept pace with the technology. And this is what Peter Leonard says. 20 years into the 21st century, the design specification for the 21st century data protection laws is emerging. The problem can be stated simply. Data privacy statutes are intended to protect human dignity, but instead they focus on data, not humans. Humans have an interest in and should have a right to reasonable seclusion. Data is completely indifferent as to whether it relates to humans or machines. Data has no concept of human frailties or needs. So humans need to make decisions about how and when data about humans are collected and used. Humans within data collecting and entities and using entities should have a concept of frailties and needs of affected individuals, but views vary. There is no ready reckoner, and it's going to be the task of our society to think deep thoughts of this kind and not to get locked into the regulations of the past. The technology rushes ahead, and the experience of the 15 years since I was last making this lecture at the launch of the anniversary of the New South Wales Society of Computers and the Law have demonstrated that technology rushes ahead. The law tends to come, as Sir Victor Windia once said in the High Court, at the end of the line, limping somewhat. And our job is going to be to try to ensure that the law does not limp, but keeps up with the technology and provides good protections for human beings throughout Australia and an example for the world. So I'm very proud as patron to be here for this launch. And as in the past, I've done this about once every 10 years. I am expecting that I will be here in about 10 more years and maybe in 20 years. And I'm looking forward to watching with close attention and satisfaction the work of the Australian Society of Computers and the Law, which at the end of this program I will duly launch, though not with a bottle of champagne.
Thank you kindly, Justice Kirby, and we certainly hope you're back in 10 and 20 years to issue the same provocations and challenges to us all as things change. But as you say, as in some respects, those challenges remain the same. So really appreciate your remarks. Whilst we don't have champagne, very sad for us all with COVID, I'd encourage everyone who is at home to pour yourself a glass of wine or a glass of water or whatever your drink of choice is, and keep those questions coming on Slido, and certainly as we morph into the panel discussion as well. Fantastic. Look, what I intend to do now is actually open up to a panel discussion, and I actually think it is the perfect segue following Justice Kirby's remarks and referencing Shoshana Zuboff and others as well, because we'll be touching on all these meaty issues. So I do want to introduce our panelists now who are on the line and very much here with us, which I'm thrilled about. All fantastic people, and I'm not just saying that I haven't been bribed. They are excellent individuals who I think will walk through those issues in greater detail as well. So I firstly want to introduce Graham Greenleaf, who was obviously referenced by Justice Kirby, who is a Professor of Law and Information Systems at UNSW. Many of you will know AUSCL and the work they do. Again, Graham is someone who's been a driving force there. And Graham, on a personal note, thank you so much, because I use that all for my casework for my PhD. So on a personal note, thank you for the work you've done. I do also want to introduce Julian Burnside. And of course, Julian's had an extensive history and again, well known across the Australian community, so doesn't really need an introduction from me. But of course, Julian has worked on cases involving the stolen generations. He's worked on cases around accessibility, and of course is with the Victorian Bar. So Julian, accept that as my introduction. And finally, Ginni Patterson, who is a professor at the Melbourne University Law School. Jeannie is not just fantastic herself, but surrounded by some other amazing people as well. Of course, she's also the co-director for the Centre for AI and Digital Ethics at Melbourne Law School, which I think, given Justice Kirby's remarks, is a timely intervention and creation on the part of the Melbourne Law School. So thank you all and welcome to the panel. I might just wait until you adjust yourself, pour yourself a drink, get comfortable before we kick off that discussion. Are you all there and live?
Yep.
Here, Deb.
Fantastic. Thank you so much. And thank you for joining us all tonight. I want to start with a sense of history. It seems appropriate given the remarks we've had tonight. And we're joined here tonight by so many people who've had a role in shaping what is going to be the Australian society as well. And there's a Māori saying, or whakatauki, if I can be bilingual for a second, which is that you walk backwards into the future, insofar as we walk into the future with a sense of what's gone before us. Much akin to that saying of, you know, you're doomed to repeat history if you don't heed the lessons of it. And so on that note, particularly Graham and Julian, noting the roles you've played historically in respective societies, the Victorian and New South Wales societies were formed just before the year that was made famous by Orwell's 1984. And has much changed over the years? Take, for example, the Australia card debates we had that died a death, and also COVID safe and the recent controversies around this. What do you think has changed in this terrain over recent years? I'll let you unmute and address that question.
I think I'm unmuted. Yes. And I should say that when I founded the Victorian Society for Computers and Law in, 1980 or 81, it was because I was fascinated by computer technology, by the way that technology worked. And one of the very first talks I went to when I was thinking about computers was a talk given by Justice Kirby, I guess in the aftermath of the OECD stuff. And I was amazed. He was the first lawyer I had ever heard of who seemed to know a bit about computers and spoke about their connection with the law. It didn't take me very long to realise that computers would have a real impact on the law. And I want to take this opportunity to pay special tribute to Graham because his introduction of AUSCL has been one of the most profound effects on the legal system in Australia.
That's very nice of you to say that, Julian. I'm actually, since we're starting off on these slightly sort of nostalgic historical notes, I want to refer to the founding meeting of the New South Wales Society for Computers and Law, which was in December 1982, and we organised to have two very special guests at that founding meeting to give us what I think I subsequently described as a prenatal pep talk. And those guests were yourself, Julian, as the founder of the Victorian Society in the year or so before we got started in New South Wales. And the other guest was, of course, Michael Kirby, who started his remarks to us, as he's already sort of alluded to, with the words, "As I walked down the Champs-Élysées," and then proceeded to regale us with tales of the people who were at that stage, or had by then formed, the OECD's privacy guidelines. So, yes, the three of us were involved in the establishment of the New South Wales Society for Computers and Law. and the attempt to get an Australia-wide association going, which we can see is now coming to fruition. But just to go on for a minute, if I may, about the question that Jeb posed of how much has changed over the years. And I mean, without going on at any length about it, if we go back to the very early 1980s, we were at that stage only looking at the first PCs coming into use, even before Apple. Oh no, Apple was there as well, but the first PCs were just starting to be used, and there was in effect no internet known at all to the general public. And I think if you can look at what has changed over three broad dimensions, and they are digitisation, networking, and surveillance and the use of personal information. And we can say that there was in effect almost no digitisation of information when these societies started. Very few transactions were digitised at the time we entered into them, probably airline transactions and not much else. There was no historical digitisation of historical materials because the back capture costs were too expensive, and there was no digitisation of non-textual content because the costs of doing that were even greater. As far as networking was concerned, while we did have PCs, there was effectively no networking of computers or other devices because they were really just getting started on developing the basic techniques of the internet. There was no mobile telecommunications, and so that what subsequently became a crucial form of networking of people and devices didn't exist. And there was almost no networking of things or objects. So the Internet of Things was not imagined. And so far as personal information was concerned, there was really very little. While the ALRC identified the dangers of various forms of public sector computerisation in particular, the main personal information that was captured in bulk at that time was by credit bureaus. And at that stage, in the early 1980s, they were only just starting to go from card indexes to any form of computerisation at all. So automated processing of personal information was almost non-existent, certainly not quite, but it was not done on anything remotely resembling the scale that we can imagine today. The international transfer of such information was pretty much limited to the financial sector and international transfers via SWIFT and other financial networks. And the voluntary disclosure of information to organisations that we're now familiar with because of social media was really non-existent, and there were no facilities to capture such information. So if we look back over this 40-year period between 1980, say, and 2020, there's really a chasm created by technological change, neoliberalism, and enormous social changes, and very great differences in our expectations as a result. But I'll stop there and pass back to Jeannie and Julian.
You know, I'm not sure that I agree entirely with that. What you've said is absolutely right. But what I think it tells you is that the emphasis has shifted over the years. I mean, I wrote my first article about computers in the law in the Australian Law Journal in, I think, 1981. And I reread it a couple of years ago. And most of the issues I picked up on seem to have worked out. But the emphasis has shifted from year to year, depending on what's going on. I mean, the COVID-19 problem right now, facial recognition in China right now. Those are things that are especially affected by computer technology, and they have obvious consequences, but the consequences shift, I think, from time to time. And incidentally, Graham, I think in 1981, when I wrote that article, the internet did exist after a fashion. It wasn't something to which everyone had access, although I remember I did write something about logging onto one computer to another computer and so on and so forth in order to commit various computer crimes. But maybe I was just being imaginative. But I think what is really alarming right now is the facial recognition technology, which is of extreme importance in China and now Hong Kong, of course. But I think even back in 1980, people who were sentient were concerned about the number of cameras outside shops, you know, in the main cities. If every single one of those video cameras was replaced by a person in spy outfit, just keeping an eye on everyone, I think people would be worried. People are now indifferent to the idea that there are cameras looking at them wherever they go, and seemingly even less worried that their images can now be digitized, linked to a particular individual, and cause the privacy problems that we are, some of us are justly concerned about. But, you know, I mean, human beings just keep on doing stuff. I think we are all subject to exactly the same faults, and we just have different and more efficient ways of engaging in that bad behaviour. And I think that's something we all ought to worry about, because especially when governments manage to behave as badly as they traditionally can. So I don't know if Jeannie's with us, but she may have a view about this.
Oh, I'm with you. So yes, I would agree. I guess that the only comment I want to make is that predictive analytics and the like also have the potential to do great good. And I think that it's important to think of ways that we can channel that good rather than stymie it in its infancy, so to speak. But I'll have more to say on that, I think, shortly, having seen Jed's question list.
Thank you so much, Jeannie. I think it's the cheat sheet, as we all say. But look, that's a topic we'll return to because, as you rightly say, I think there's a difference between predictive analytics in some spaces, and i.e. social services, where it might prevent great harm based on what we know. And then there's the other side of predictive analytics, and we think about that as consumers, which I'm sure you'll all have a lot to say, which might be the other side of the coin. I just wanted to mention we've got some great questions coming through on Slido. Those are not being ignored. They will be addressed in a second. We've got some great questions about both the society and so what we might pick up in terms of different channels of engagement or focus areas. So just to let all of you know on the chat, we will soon be handing over to Slido questions. So please keep those coming thick and fast because we'll tackle those in a second. But look, the discussion you were all just having was really also about technological diffusion. So it was about the rate of the uptake of different technologies throughout society. And I suppose how our patterns of use change over time. And to be very frank, generationally, and many people on the call I'm noting tonight in my generation might well have been those people who started their LLB or their JD at law schools when Facebook wasn't really a thing, and might literally have graduated 3 years later in a transformed world. So I did want to put that out there as a question around, you know, things have changed, but what really, while some of the issues might remain the same, I think it's clear from all of your comments, and I was just listening very carefully to you, Graham and Julian, and certainly Jeannie as well, it's the pace of change which looks very different. And if we go back to Justice Kirby's comments as well about that, some of the issues remaining the same, but again, whether the law in a particular area is fit for purpose, I wanted to return there. So I just wanted to actually touch on that. And could you describe for us some of the challenges you see with this rapid diffusion of technology? And I'm thinking primarily here of privacy, which, you know, Julian and Jeannie, you both just touched on as well, but also other concerns. I know competition law comes into this. Did you want to pick up on that thread and talk about what does that mean for us? So if we observe these trends, what does it mean for us all? And how should we intervene?
Do you want me to start?
Please do.
Okay, thanks, Jed. So continuing from actually those lovely threads that Justice Kirby put out for us, certainly I think that privacy and data rights are really important, and not just in our digital interactions, but as Julian has made the point, actually in how we interact in public spaces. Privacy is becoming increasingly important as we're tracked in ways we haven't started to realise. And I certainly agree we need reform in this area. But I'd also like to make the point that when we're dealing with new technologies, it's not a one-stop shop. There's no one law that is going to resolve these problems. There's a vast suite of laws that are going to be relevant to the relationship between citizens and the digital technologies that new computing capacity is enabling. So if I go to my field, which is contract and consumer law, we see a lot of importance placed on the rights of citizens or consumers to control the collection of their data for predictive analytics. But quite frankly, it's unreasonable and unrealistic, I think, to expect consumers themselves to exercise control over how their data is collected and used. So if I'm looking out at what I'm imagining are out there, I'd be interested to wonder how many people in the audience do read privacy policies when they're signing up for digital services. And most people don't have the time to do that. And you might be interested to know that the Norwegian Consumer Council found it would take 30 hours to read all of the terms and conditions relating to privacy of just a few popular apps, which included Netflix, YouTube, Facebook, Skype, Instagram, and Angry Birds being most essential. So I think this means that we need to value privacy laws, but we also need to look beyond privacy laws in all sorts of fields. We need substantive protections for consumers, for consumer citizens, in fact, in their dealings in society, in addition to privacy. The AUSCL recommended unfair contract terms law, prohibitions on misleading conduct, a prohibition on unfair trading, and I think you'd find analogues to that in other areas of the law as well, providing that substantive protection on citizens' rights. And we also, I think, we need to be applying our minds to how we regulate algorithmic decision-making in these contexts. And as Julian has mentioned, the uses that are made of surveillance technologies. Julian?
Well, Jeannie, you mentioned the ACCC's, some of its recommendations in its platforms inquiry about unfair contract terms and unfair trading practices, which, you know, if the government does take them up, will make the ACCC a major player in enforcing privacy standards as well. But I think it's also worth mentioning, given, as Michael Kirby pointed out, that Australia's Privacy Act is now so far behind the international standard that's been set by the European Union's GDPR, that we need to remember that their platforms inquiry report made recommendations which are basically a once-in-a-decade opportunity to bring the Privacy Act much closer to that global standard. But when the government responded to that ACCC report in December last year, before we all became completely distracted by COVID-19 problems, the government's response was fairly half-hearted. But nevertheless, it did say that it would legislate beginning in 2020 with maximum penalties under the Privacy Act increased to the greater of $10 million or 10% of the Australian turnover of a company found to breach the Act. and a mandatory digital platforms privacy code developed by the OAIC. And those developments, and I think probably particularly the 10% of Australian turnover maximum penalty, would be a considerable Australian contribution to the global control of surveillance capitalism. And the ACCC also supported in principle the right of individuals to sue directly in court under the Privacy Act for compensation, and recommended many other things that were close to GDPR-style reforms, such as a right to be forgotten. And for that matter, they also said they'd review the question of a tort of serious invasion of privacy in 18 months. So, you know, we all need to sort of keep focus on what they have undertaken in many cases to do to reform privacy law, as well as the consumer law reforms that you're right are needed.
I must say, I think the discussion so far raises squarely the question whether young people, your generation, Jed, whether they're as concerned about privacy as we were. My impression is that they're not as concerned about it, and the use of the internet and various aspects of computer technology simply make the privacy problems more acute. But my clear impression is that the current generation of young people are just not as worried about privacy as we used to be.
And I think that's an interesting proposition. I think many people on the call will take that further. I'm sure they will on Slido. I'm just acknowledging the significant interest on Slido in the facial recognition aspects of that. So, Jeannie, as you were talking, and you know, rightly reminding us, it's not just about privacy. I'm mindful the Australian Human Rights Commission have an inquiry at the moment which is broad-ranging and touches on a whole range of different areas of law, rightly so. And then there's privacy laws and there's competition law, which are all being bitten off in small chunks at the moment. I think people might find that rather amusing because everyday people see it as one, as a whole, as a totality. So that's fascinating in itself. I might let you comment there on what's kind of being missed in those discussions too.
Which one of us would you like to comment?
Jeannie, dive straight in, because I know you're really connected with these issues for the work you're doing in Melbourne.
Well, I guess there's 2 points there. I wonder, I'm a parent of young people myself, as many of us are, and I do wonder about assumptions about their views to privacy, because I think actually one of the things that's really important to do is to ask and engage with young people, as I'm sure Julian would agree. And I actually wonder if views will be changing. There's been a lot of attention recently about, for example, just what TikTok does in the data that it collects. So it'll be interesting to see, I think, what happens in that space about whether the delights of TikTok rule over concerns about data being hooved up, facial data being hoovered up and used as training facial recognition technologies. I leave that out there, but I think that's a question to be interesting to just have more empirical information about. In terms of surveillance capitalism and surveillance technologies, there's no doubt that we are living in an age of surveillance technology. But I'd also like to draw our attention to the people who don't have access to technology. The digital divide is still a really important issue, both in Australia and internationally, or what we might call digital poverty. It's easy to reject connectivity when you've got it. It's not so easy to reject it if you don't have it, particularly at this point in time. So I think it's important we remember to focus on that point. I noticed when I was doing some research for this that the recent RMIT report on digital accessibility made the point that 4 million Australians still access the internet through a modem. And I'm sure we're all aware that leaving people out of data sets is as problematic as collecting data without purpose permission, because those data sets are training algorithms that are making decisions about resource allocation and medical treatments that affect the whole of our society.
Seems to me that the problem comes down to two things. First, how many people do you know who will not install an app if it's free or there's some side benefit offered with it? And second, how many people do you know who actually read the conditions of use all the way through? Now, that's where your privacy disappears. Now, I don't think I've ever met anyone who's read the full terms of an app before subscribing to it. Now, you're either concerned about privacy or you're not. My instinct is that computer technology makes it very easy for people to be less and less concerned about privacy.
And I wonder, Julian, if I might be provocative from a generational perspective, if people are actually worried about instrumental privacy, if you will. So that's a bit of an invented term, but the benefits you get from using an application or a particular form of technology relative to what you think the trade-offs will be, which to Jeannie's point, I think was all about what you judge to be what you're sharing. And I actually think Jeannie's point about TikTok is a fascinating one, because I think you actually might see amongst the younger people geopolitics entering into their decision making as to what am I downloading and who's getting access to it, which might be the alternative to traditional considerations of privacy. And I did want to throw that out there, that maybe it's a lot more nuanced than what we're positing it as. And hand it back to you all to comment on that.
Yeah, I think that's the right point, Jed, that it is more nuanced in different generations, and people who are younger than me and Julian are probably much more selective and sophisticated in which aspects of their privacy they wish to protect. And while I'd accept Julian's point that the protection of privacy through careful reading of privacy terms and conditions doesn't happen, that's because that's the wrong model of privacy laws, to base them on consent like that. And the approach of insisting upon privacy maximising default conditions in technological applications, privacy by default, and fairness in the way that information is collected, is the way that privacy laws must develop in the future, and be based far less on spurious notions of notice and consent, except where it's very clear that that can be, delivered effectively. So I think there is room for a different approach to privacy laws and different catering for the sophistication of users.
This is the very point that Peter Leonard made, really, where he said the consent principle, which is one which the OECD gave a lot of support for, is really just not working, because no one reads the consent document. So you've got to then think of what you put in its place. And I think he's thinking conceptually. He says you've got to go back and ask, why do we have data protection? What is it there for socially? What is the purpose of privacy protection? And when you go back to the really fundamental questions, you may get some surprising answers.
It would be very interesting to see the public response to a law which said in substance, people who wish to sell your personal information must declare so plainly in the app that you're downloading, and if they don't, they're subject to a fine of some appropriate amount. I suspect that would leave Australia as a backwater in the spread of apps. I could be wrong about that, but I think a lot of people wouldn't care that their information is being used and sold, and B, if they were aware of it and were concerned, they would simply stop downloading free apps.
So that brings us to an interesting point in terms of the Slido questions we've had this evening. And one of the questions is indeed about how proactive and interventionist governments should, and corporations indeed, should be in addressing misinformation and moderating content on social media platforms. So it's a bit from left field, but it is getting to a few of the topics we've touched on already this evening. Jeannie, I know you were about to hop in on that previous topic, so I might hand to you first, given the work you're doing at the moment on that topic. What's the right balance in terms of regulation? What should we be attempting to regulate, which is something we're grasping at as a panel, which I think is the topic as a society we're also grasping at. So I might hand over to you, Jeannie, to have the first comments, and then hand back to Graham, Julian, for final comments as well on that.
Well, what a hard question to answer, and I'm sure, in fact, that Julian and Michael and Graham will have a lot of things to say about regulation of social media. But what I'm going to just make as an initial point is that we can't go back from a world that's connected through social media and various apps and the like. Every child in this state at the moment is learning online through various digital technologies that are collecting data about them. Now, we have no choice. The parents of those children as children have no choice other than to be using that technology. And so I come back again to the point that keeps getting made. It's not enough to say it's a matter of consent. And I know that all of the panelists have made this point, and I'll make it again. It's not enough to put the responsibility on the individual, because in many circumstances, either the individual doesn't necessarily have the information to choose in their best interest, or in the case of education technology that we all have to rely on now, they have no real choice. So I think it's fundamental that we need some substantive fairness protections and substantive governance protections that ensure that the technologies that have become essential for us to connect and learn have features built in them, privacy by design and other protections, which means they're safe for people to use. Over to you, team panel.
Well, the fact that we're in the midst, or perhaps the early stages of the coronavirus pandemic, certainly shows, how vital it is that dangerous misinformation is not spread via social media or by other electronic means, because it is potentially catastrophic for our society if that is the case. It's also potentially catastrophic for democracy if information that is clearly completely false is able to be spread to manipulate people's voting behaviours, as we have seen the attempts to do via Cambridge Analytica, and of course we don't know to what extent that is now continuing, but the stakes are, all I'm really saying is the stakes are very high, and even in the United States there has never been complete freedom of speech. The standard example of the person who yells fire in a crowded movie theatre or stadium has never had that expression of free speech protected, and we don't want to be dealing in absolutes. We need to find what the proper moderation is with the new technologies that we're trying to deal with now. But absolute freedom of speech is certainly not the right answer.
I agree with that, but I think the problem goes a couple of layers deeper. The first problem, just picking up on what Jenny said, is to have a government that is going to regulate right to privacy in ways that conform to the concerns that you and I have, Graham. But you also need a government that's going to be willing to do that, even though it will cost. That's the difficulty. I think it's politically very difficult to get support for the sort of things that we're concerned about, because, as I said before, I suspect that there's a generation coming up who are less concerned about privacy than our generation was.
Did you want to dive in, Graham, and have a response to that?
Well, I was just going to add one thing that is somewhat relevant to it, and that it is that the misinformation we're talking about is not solely internally generated from within our own countries any longer. It's becoming abundantly clear how much foreign interference there is in the transmission of misinformation across our networks. And I'm not, you know, that's not so much a privacy issue at all, Julian, but rather, you know, an issue of the integrity of each of our countries as democracies, at any rate. And I think a lot of people's minds are changing quite considerably as they come to appreciate the extent of foreign interference in the information we're obtaining on social media and the attempts to interfere in democratic processes.
So Graham, I might dive in on that note. Sorry, Jeannie, go ahead.
Oh no, I was just going to make the point that I think that's entirely right. That I'm entirely optimistic about the capacity of the younger generation to seize on and deal with these problems. I think the point is that they may do it differently to they've done it in the past. I think that certainly the students I teach are very engaged with these issues about privacy, surveillance, free speech, but their modes of dealing with those issues are perhaps different than they were when I was a university student, for example. And I'm sure Michael would have views on that. He comes and talks to our students every year, and I think we find that they are full of passion and belief and understanding about the need for robust engagement in to preserve democratic processes. And perhaps highly sophisticated in their use of technology.
Absolutely. So I want to dive into a very hairy question, but it's a really good one from Priyanka Nair on Slido. So thank you, Priyanka, for raising it about global regulation. So we spoke about the OECD guidelines. People like myself are very engaged with their principles in areas like AI. So we've been talking to the OECD for disclosure because we think there's some sensible middle ground there about global regulation of spaces like that, which don't hurt Australia, but which help Australia in a smart way. But the question Priyanka raised, which I think is an important one, is, has the money and functionality, quote, of unregulated tech giants meant that we have sold out on advocating for global principles to regulate AI, automation and data? And so I might ask that really tricky question, and I think it's one that touches on multilateralism, and I'm just mindful we've got a speaker in a second who's going to speak on that very topic. So, you know, we've chatted about the challenges domestically, about how we channel all of this, about interference, Graham, as you rightly pointed out, in our own domestic political sphere. And I might touch on that too. So what do you think about the prospects for globalism, global regulation, global responses? Because it seems like we've got a multipolar world emerging where we have China in one corner, the US and others in other corners in the EU. And I might draw you on that very topic. How do we effectively govern emerging technologies? Graham, you might unmute, sorry. Just to unmute, Graham.
Yeah, we were getting feedback, so I muted it. Just staying with the example of privacy protection and the example that Michael Kirby raised of surveillance capitalism as explained by Shoshana Zuboff, and the fact that what you have there is gigantic surveillance capitalist platforms, Google, Facebook, Amazon, a handful of them with which the world has to deal, and even the strength of the European Union and its laws, particularly the GDPR, is not capable just by the European Union of dealing with that. And it requires an effort where many countries bring their own privacy protections up to the necessary standards so that the platforms are facing worldwide rejection of the business model that they're trying to impose on people. Then also, it can't be dealt with solely via privacy laws. Competition regulators have at least as much a part to play in doing the most important thing in relation to regulating those platforms, and that is stopping them from relentlessly acquiring more and more companies that give them greater and greater monopolistic powers in particular parts of the information economy. So it's not a coordinated effort, but it's one that requires worldwide effort, is the way that I put it.
I think if I can just comment on this, I think if we're interested in multilateralism, we'll all be watching very closely the US elections, because there has never been an administration that is so anti-multilateral. I mean, even if you look at the absolutely existential issue of nuclear weapon control and non-proliferation, President Trump has really withdrawn from all those things that his predecessors, Obama, George W. Bush, and Reagan negotiated. Reagan with Gorbachev, and you know, so it's a really bad direction the world has gone in the last 3 years. And if we want to get back to multilateralism, we need leadership, and that really does need a change in the administration of the United States of America.
I agree. I say, for me, it's going to be very difficult to get multilateralism operating. Maybe it's time for Michael Kirby to go for a walk along the Champs-Elysees and back to the OECD. I should just mention that interesting question comes from Priyanka Nair, who is the immediate past president of the Victorian Society for Computers and Law, and a very well pitched question.
Absolutely, and appreciated from our end too. Look, we've had a whole range of comments come through, on some on facial recognition, others on the function of the society as a whole, and I know we are getting to those as we move through the evening. I'm also conscious that Francis Gurry has joined us on the call, and we're honoured to have him listen to this discussion and debate, actually, which I'm going to keep going for another 5 or 10 minutes, because I think we have a few issues to get through too, and certainly your questions as an audience, and then we'll hand over to Francis. And we're still ahead of time, you'll be pleased to know. That's a great thing. So I might move on there and talk about some other issues that we've raised as well. So I know we've talked about education as a piece. So one of the questions is around, is it time to talk about digital literacy? Certainly the questions framed at primary level and tertiary as well. But I'm conscious we've also had a number of reports in the legal space. So the Pearce Report in 1987, and that might seem a long time ago. Indeed, I actually bumped into Ron Sackville, who had written a report a long time ago, and I added a chapter, courtesy of Andy Durback, to his report on poverty in the law. And it was about LGBTI people, so lesbian, gay, bisexual, trans, and intersex people. And boy, how times change, because one may not have written that in a report, published back then, but by Lord, it's a topic now. So I did want to pick up on that, on the Pearce Report in particular. And Jeannie, I know you're probably closer to this, being in a tertiary institution, being in a law school yourself. But it contained a number of recommendations, some of which were realised insofar as legal education is concerned, and some of which were deferred. I don't want to get into detail about that. I think, ironically, one of the recommendations was that we needed to maintain the number of law schools, and it seems they've burgeoned since the publication of this report. So I shall leave that comment there. But I did want to ask you that question about how you think we're progressing in aligning the expectations of teaching, of pedagogy, and market and community expectations too. So I just want to draw you on that first, and then I will defer to all of the panelists here tonight about how you think we're tracking. We've been talking about the big picture issues, advocacy, about intervening, but I just want to draw you on how you think we're preparing the next generation, people, behind me perhaps, for leadership roles, and what your thoughts were on specifically the Pearce Report, which Jeannie, I think you know a little bit more about, but education more broadly in this space. So we're equipping people with both those technological skills and the legal and critical thinking skills we need as a society. Whoever wants to dive in first, Jeannie, I know I pointed you out, but whoever wants to dive in first is more than welcome.
Just unmute your mic, Jeannie.
Sorry, I'm muted. Okay, I will say a few words then, and then I'm sure my great colleagues will have some things to say. So one of the things that came out of the Pearce Report was, well, three things: the value of libraries, the value of small group teaching, and the role of skills-based teaching. And I think that last one's particularly pertinent now, though they all probably are. I am always reminded in this context of something that Justice Frank Easterbrook, who's an academic and judge from the US, he's actually from Chicago, so he's a proponent of the Law and Economics School of Legal Analysis, and he said that at a law and cyberspace conference, in fact, he was the opening speaker, and he said the law of cyberspace is equivalent to the law of the horse, and he was not being flattering. He thought that it was a sideline that contributed very much to scholarly discussion, and it strikes me how much things have changed, because as anybody who's read the Susskind's work will know, computers have and algorithmic tools are transforming both legal practice and all aspects of society that lawyers will be asked to advise on. So the question I think that then is raised is, should we have courses on computers and the law? The answer is, of course, at most universities we already do. All of the universities represented here are teaching in these areas. University of UNSW, Melbourne Law School, and the others who are contributing. So the real question then is whether it's enough just to have electives in those areas, or whether new technologies have to infuse the Priestley 11, as they're called, those subjects needed for admission to practice. And I suspect the answer there is that they, to some extent, they already are. It's really important that students, I think, have the confidence and skills to interrogate new digital technologies for the reason that Julian and Michael and Graham have pointed out, to understand what's happening to civic rights, democratic processes and the like in the face of technologies that intrude on every aspect of civic society. And as I said, I think that might already be happening. Certainly when I teach contract law, when I teach mistake, I am referring to a recent decision of the Singapore Court of Appeal, which is on mistake in the formation of a smart contract on a cryptocurrency exchange. So over to the panel.
Well, I think one of the problems with what the young lawyers have to come to today and to deal with these subjects is that we of the older generation never really provided them with the good building blocks for dealing with the conceptual questions that are being debated here. I mean, we never had in our constitution, as most constitutions do, some basic principles, and we don't seem to be able to even talk about it. And likewise with statutes, we haven't really updated. Look at the pathetic situation we're in with the Charter of Rights, only in 3 states of the Commonwealth. So this is the problem for law schools. I don't want to get sidetracked in this big issue that concerns all of society, but in legal education, one of the problems is that the older generation didn't really give a proper foundation for dealing with this conceptually, and therefore to go back to basics and to go back to the fundamentals, as Peter Leonard did in that article that I referred to, is difficult for them, and it really needs leadership from members of the profession and leadership from the academics in their law schools. Maybe I should also add leadership from the Australian Society of Computers and the Law. People have got to get off their backsides and start writing and talking and engaging in Zoom conferences and really raising this as an issue, so that younger people can't say, oh, well, that's really not for me, because it is for them. One thing that Peter Leonard said was that he wasn't saying that you've got to take over and provide legal regulation against people's wishes. He said what is needed is legal regulation to deal with this beyond the consent model, which involves people with frailties and needs, as he put it. In other words, he was saying there are some people who have a vulnerability that for which the consent model is not really an answer. And that's not everybody, but it shouldn't be beyond the wit of human beings and of Parliamentary Council to start drafting principles that could be adopted in particular countries, and then you put those together and you go to the OECD and you start suggesting a multilateral solution. The OECD guidelines, never forget, grew out of the Nordic guidelines and principles, and they in turn gave rise to the European Council of Europe guidelines, and then the EU guidelines, and then the OECD got their hold on it. So you've got to start somewhere, and this is an amazing technology, and artificial intelligence is in the wings. And I like very much Peter Donkin's opening words in this conference. I think he listed a whole range of issues that should be on the agenda, and they should always be sent out to members of this society, so that and there should be subgroups to draft things and give them to politicians and try and get them to do something. Australians have got to get out of this lethargy of saying it's just too difficult, we can't do anything. Look at them over there in New Zealand. You know, New Zealand has ratified the treaty to ban nuclear weapons. Little New Zealand has done it. It was an idea that came out of Melbourne. They got the Nobel Prize for Peace, and our government didn't even give them a cocktail reception with Australian sparkling wine. I mean, nothing, ignored.
And Justice Kirby, I might pick up there on that point. We did have a question earlier this evening from a young person saying, I want to be involved and engaged. How do I become involved and engaged? And the answer is join. Join. And you'll hear that throughout this evening. Get involved, participate, reshape things. If LB Sachs from my home country can pull himself off the ground after having his limbs blown off and craft a Bill of Rights, then every Australian, with all of the privileges they've been given, can absolutely contribute, as you rightly say, Justice Kirby, to creating a legal future we want as well. So I did want to leave you on that note of bizarre optimism, and those of you who know me on the call will know that that's not uncharacteristics, to recall some of the people who've struggled greatly but have actually overcome, and they've done great service to their community as well. And Justice Kirby certainly mentioned New Zealand, and if you think about OPCAT and various conventions New Zealand's signed, they've been directly involved in preventing deaths in custody and other things which concern us greatly as a country. So the question that Jeannie raised, actually, which is going beyond just narrow areas of law, becomes really, really, really important. And on a really optimistic note, because I know we have Francis Gurry waiting in the wings, who I'm going to introduce in a second, I did want to ask you all on the panel, including yourself, Justice Kirby, we have an international audience with us this evening. They're joining us from San Francisco. I got a wonderful Slido question from Finland. So just to know, we are reaching into all of the areas of the world, and New Zealand too. I can see people joining us from Auckland. What do you think the world can learn from Australia? The world can learn from the talent, the world can learn from people who are based here. And where do you see the major advances in law and legal tech? Just noting we have people from the Legal Forecast, the Law Society, etc., joining us tonight. Where do you think that's heading, and where might the strongest contributions be in terms of a better, more just society? It's a big loaded question, and I'll hand it over to whoever wants to speak first. Jeannie, I can see you're speaking. Take away.
Oh, no, I was just getting ready to listen to the views of the rest of the panel on that one. What can Australia contribute? Well, I'm going to give quite a technological answer, because you referred earlier to the Centre for AI and Digital Ethics, which you said sat in the law school, Jed, but in fact it's a cross-disciplinary centre. It sits in engineering, science, arts and law. So we're trying to bring all those perspectives to how one responds to new technologies. We're in fact working with VSCL on those issues. And I think what Australia brings is, of course, the cliche about its creativity and innovation, which I would add is true, but also we have great expertise, for example, in managing technology over vast distances. We have a society, a community that's spread remotely across the place. And if you look at some of the things that are happening in remote parts of Australia with new technologies, they're quite remarkable. So I think we really do have something to contribute, but we also have the insight of people who've been fighting for civil liberties for years, who also bring the need for an equitable and just approach to the distribution and use of those technologies.
That's wonderful. Can I just also add on a lighter note for everyone joining tonight? I had the most wonderful message on Slido. People in WA suggesting they're joining as the most newly formed country. So there we go. You know, a state doing it really well under the conditions they have at the moment. I thought you'd appreciate that. And carry on.
Well, can I add to what Jeannie has just said? If you ask what have we done in law that has been really good and original in Australia, I would say we did a lot at the beginning of the century, but we then ran out of ideas. And but when HIV came along, Australia took the advice of the World Health Organization, worked multilaterally, and then back home, with the aid of politicians on both sides of the aisle, it started enacting laws for needle exchange, laws to get rid of the laws against gay sex, laws for decriminalising sex work, and all the things you had to do. They weren't easy laws to pass, but they did get through the help of civil society, the help of scholars and academics, of political leaders, and bipartisanship. So I think the society, the Australian Society of Computers and the Law, ways in which it can copy the model of how we did things on AIDS, because we saved lives and we did that very well, and that's something we can put forward to the international community as things that you can do even in a sometimes hostile environment. So I think we do have some models, and it basically gets down to doing things well at home and then trying to sell them in international agencies, especially of the United Nations and the OECD.
I'd like to add here that something Australia has a good history of doing is enriching the public domain. We have a very creditable history of innovation in free and open source software, which of course, you know, at least 50% of the software that runs the internet is free and open source software. And Australian software developers have contributed a significant part of the utilities that do that. And also in free and open content. I can raise the example of AUSCL here, of showing that a very large part of professional information in one area of the profession can be put into what is effectively the public domain and sustained in it. And AUSCL's 25th anniversary is this year, so it's a good example that free access to legal information can be built and sustained. But where we need to go now in the future is, if a great deal of the legal information in future we hope we will be dealing with aided by artificial intelligence, then both the tools that are used to create AI applications to law and applications in specific areas of law need to be made available to the general public and not solely in proprietary hands or government hands. And this is actually one of what I thought were the very good conclusions that Richard Susskind and his son Daniel have concluded in their book about the future of the professions. And they basically said the professions have to find some way to maintain their existence in the face of AI, and the way to do that was for them to contribute to and control much of the development of AI in their areas of professional expertise. And as lawyers, we need to ensure we don't hand over the future control of legal information to companies and governments.
Julian, over to you.
Yeah, I don't want to sound pessimistic, but a lot of the solutions which have been mentioned depend on having a government that will respond according to the sense of the thing rather than according to the market. And that we lack in Australia. I mean, I think Michael Kirby's comparison with New Zealand is a powerful one, because New Zealand seems to be guided by what is going to be good for the area of thought or for the world, not just for the country. And that is a big, big difference. I mean, it's very interesting when you consider that where it was in, I think, the first Rudd government, there was a suggestion that we should have a statutory Bill of Rights, and Frank Brennan ultimately reported and advised that we should have a statutory Bill of Rights, and Kevin Rudd unilaterally decided we would not. And that made us the only country in the world which in the 21st century decided against having human rights protection. Now, if we can be that limited in our thinking, then it worries me that we may not provide the sort of leadership that the world needs in relation to the use of artificial intelligence, for example. I mean, I agree completely with Jeannie's analysis. We have done great things in the past. You know, in the early part of the 20th century, Australia did achieve some very good things, but we seem to have lost the art of doing that. And that's a great pity, because Australia still has great capacity for inventing things, for discovering things, for learning things, and we just need to be a bit better at implementing them.
I'd like to just say one thing, because I agree with a lot of what Julian says, as usual, but I do think we've handled COVID much better than most countries. You know, you've got to give it to our government. I think our federal government and the state governments, and working together cooperatively. Now, this was a desperately dangerous thing, but the fact of the matter is we've only had, and I don't dismiss it, but 110 people have died in our country. I mean, it's a magnificent achievement, and it's still going on, and therefore it does show, when we get our act together and when we get our constitution arrangements together and we get the best advice, because that's what we've had in COVID, we can do much better than most other countries. And so I wouldn't be quite so pessimistic, Julian. We've got to study COVID, see what was done there and how we can apply those principles and methodologies in dealing with the issues of the future of humanity and of the human society and of technology as it impacts on them.
I agree with that, although it's interesting too that New Zealand outreached us in relation to the dealing with COVID. Maybe that's just a function of geography and small size and so on, but they did do better than we've done. But that said, it's interesting that COVID, which is a very serious threat, it threatens the lives of 1 or 2% of the human race. Our government has reacted very well and very swiftly in response to it. But what about the risk associated with climate change, which threatens the lives of every single human being? We've not done anything much about that.
And nuclear weapons too. I agree, but we're starting. We're going to get better and better. We must be optimistic. We must have an optimistic attitude, and relying on the experts. I mean, that's what they've done in COVID. That's what President Trump willfully would not do, and the UK also, and Brazil. You know, I think that's what they've done, and what we've got to do is get our society to be good at lobbying, to be good at working with heads of departments and departmental officials, and getting to know the people who are the power brokers and in politics and in the bureaucracy. Get the ALRC back into the picture, working on these things, and then perhaps Australia can be a good example to the world in this area.
And Justice Kirby, Graham, did you want to dive in?
I was just going to say, picking up on Michael's last point, that one of the things that the ALRC is currently considering putting on its work agenda for the next couple of years is automated decision making. Now, there is a real opportunity for Australia to take a leading role in the development of principles that would be relevant worldwide in terms of automated decisions and how to avoid future robo-deaths. So that's one that should be encouraged, and it's one where the Australian Society for Computers and Law could take a considerable interest in promoting good law reform in that area.
And Graham, that's a call to action if I've ever heard one. And I hope people certainly joining us tonight take that on board as well, because I think there's scope for change there. I will second Justice Kirby's call to optimism. Actually recalling a personal bit of law reform I've been involved in around the Sex Discrimination Act, which changed in 2013 to include new grounds. And to the point about the government of the day, of course, our parliaments are made of very diverse people. They still are, which is a good thing. And what we saw there was people from all stripes coming together, whether they were in the Greens or whether they were Liberal senators like Sue Boyce or people like Chris Pine, actually working together for some good outcomes. So I share the optimism, and that's definitely the note I want to leave people on as well, which is that we have to struggle, but we'll eventually get there. And I'm sure many of the issues people have raised, including on our Slido discussion, we will tackle as a society. But without further ado, Francis Gurry has been waiting patiently. I now want to hand over to Francis. He does not need an introduction to many of you on the call, particularly in the legal fraternity, but you will be aware he's the Director General of the World Intellectual Property Organization. Appointed in 2008, he's our man over there, to use those terms, which are probably well outdated. He was reappointed in 2014 for a final term. This is it. He is still in the seat, and we're really honoured to have Francis Gurry join us this evening. I wanted to thank our panellists before we hand over for their really incisive commentary. I'm sure this has been recorded, or at least notes have been taken along the way. So thank you for all of you who asked questions. We couldn't channel them all, although I did note the comments from some of you that we were channeling what you were asking. So it's good to know we're roughly on track. For those questions that weren't answered, we'll come back to them in the moderated chat within the next 10 or 15 minutes. Pretty consistently, but I do want to hand over now to Francis Gurry without further delay. Thank you, Francis.
Thank you very much, Jed. Well, distinguished participants, it's really a privilege, and thank you for the invitation to join this launch and celebration of the Australian Society for Computers and the Law. Let me pay tribute to all of the distinguished panelists. It was a fascinating conversation that I was able to tune into just now for the last hour or so, and a great advisory board, a fantastic advisory board. But if I may, I'll pay a special tribute to Justice Michael Kirby. We often, I think, devalue words by indiscriminate use of them, But Michael, of course, is truly a pioneer and a visionary. And he's always had his eye not just on what the law is, but on the social and economic trends that are shaping the direction of the law in the future. So thank you, Michael. And I pay tribute also to Marina Yastrabov for all of her dynamism and leadership in bringing about the Australian Society for Computers and the Law. But two reasons why I think the launch of the Australian Society for Computers and the Law is extremely important. There are a lot of things one can say, and one could go on for hours, but I've just mentioned two. I think we're living in a world which is, obvious comment, of a multiplicity of crises. I don't know whether you understand what's going on. I certainly don't. But there is just a multiplicity of crises that we're facing. Now, I'd like to mention two of them. The first, I think, is a profound challenge to our institutions that comes out of the speed of the development of technology. And I think it's aided by the power and the reach of new technologies and the extent of the dependence of society and the economy now on technology. And we live in a system which, put brutally says that you can do anything you like, provided that it's not explicitly prohibited, as opposed to a system which says you can only do what is explicitly authorised. Now that leaves us in a bind, because the speed of development and the radical nature of technologies now are throwing up new use cases which are unforeseen, of course. And that's happening at an increasing speed. And also, as I mentioned, radical nature. I know in the conversation you've covered a number of examples of this. There is a multiplicity of examples. You covered the Cambridge Analytica, Facebook example. In a different field, you could look at the editing, hereditary editing of the human genome, which is unforeseen. Now, I think that situation, which is placing a crisis on our legislatures because they necessarily lag, and it's placing a crisis, I think, on our courts because they're being confronted with questions with which they are perhaps for which they're inadequately equipped. Now here, I think, a learned society, as we used to call them, a society like the Australian Society for Computers and the Law is extremely important, because it can bring together the expertise, the first-hand experience, interdisciplinary interaction, and intergenerational interaction. And all of those things are not necessarily present in our representative institutions, but exceptionally important. Now, that profound institutional crisis, I think, that one could talk about for a long while, is compounded by another crisis, which you again have mentioned in the panel discussion that we've just had, and that is the crisis of multilateralism that we are seeing. And it's a real crisis. And by the way, if I may, I know Michael Kirby is a leading luminary of the OECD, but the OECD is not a multilateral organisation. Its membership is about 50 of the richest countries in the world. There are about 192 or 194 countries in the world. So it's not a truly multilateral institution. It's a wonderful institution, but let me just make that point, if I may. Now, the crisis of multilateralism we see is really very profound. I think it's got two elements. There is a challenge, a profound challenge, to the idea that international cooperation is the best way in which to tackle or address a problem. That we've seen, and you've mentioned the country where this is receives its most forceful expression. It's a challenge to the very idea of international cooperation. And a separate, I think, element of the crisis is a challenge to the particular expression of multilateralism that we now have, which dates from the 1940s and dates from a completely different world, geopolitically, economically, technologically, socially, every way in which you look at it. So there are many criticisms, very often justified, of the existing expression of the architecture of multilateralism. So we've got both of those attacks to deal with. Let me just give one example, because I think it would be a mistake to think that the tendencies for closure that we are seeing in this world, which are associated with the rejection of multilateralism, are emanating from one country only. I think they're emanating from many countries across the world. And I'll give one example of some of the dangers that this entails, which is the example you've also been discussing in this panel, which is the GDPR. Now, the GDPR, the General Data Protection Regulation in Europe, I have no comment on its content, right? We are aware that the idea was to have a human-centric approach to technology. I have no comment on its content, or its substance, just a comment on the process. This was not a multilateral approach. It was a multilateral problem, or it is a multilateral problem. But the Europeans decided to go the path of developing a European solution. Now that has led to an interesting phenomenon, which is that the first mover, provided it has scale, makes the global rule. Because Europe is a market, of course, of 360 million consumers, everyone would like to be in it, and if you adjust your systems for the European market, well, you might as well adjust them, as everyone knows and the computer specialists know, for the whole world. And that, I think, leads to the possibility of regulatory competition. And this is one of the downsides of abandoning the multilateral approach. Because Europe has done it, you might be happy with the GDPR, or basically happy with it, but China can do it also. And so too can the United States. And so too in this area could India, for example. So if you have regulatory competition, each trying to fashion a law which is going to serve its interests, even its values, better than perhaps another approach, well, we're going to end up in a total mess in this interdependent and interconnected world. So here again, as many have commented, I think the Australian Society for Computers and Law has a great role to play in reaching out across the world. But the question was asked of the panel, what could Australia contribute to multilateralism, and I think that I'm not in disagreement with anything that's said, but I think one of the things that it can contribute is process. Rather than looking at the substance of particular issues, we've done this well, we've done that well, this whole process of how you actually develop a global society and global regulation that is appropriate for the global challenges that we are facing, and that is appropriate for the global use of technologies, because that's what we are seeing. So congratulations once again to the Australian Society for Computers and the Law. It's really a fantastic development, and to all of the movers who have brought this about, and it's a privilege to be able to abuse a little bit of your time just at the end here, but I wish you all the best, and I certainly personally will be following very closely all of the developments of the Society. Thank you.
And thank you kindly, Francis. And it was a welcome abuse, if I might use those words, on dangerous territory. But of time, I think we're actually doing extremely well for time. We have just about 4 minutes into 7 o'clock, which was meant to be the hard stop. So we really appreciate those remarks. It's left to me, after that really enriching discussion, which traversed a few areas, and I've been following the discussion on Slido too, so please don't think the comments you made have in any way been ignored, both in terms of the content of future sessions, which I picked up on, particularly the question around the work that Jeannie and co are leading in Melbourne. There will be future areas of focus that pick up on this very rich discussion point, which is about multilateralism as much as it is about regulating within Australian law. And we actually look forward to picking those up through dedicated seminars and discussions nationally and within different states and territories. So please be reassured that is being picked up as you type, which is fantastic. I should also add, if you have suggestions in future for future speakers, please do post those to Slido, because we're looking to explore that as well. I know there's an openness on the part of everyone involved to make sure we widen the circle as well. Look, it is left to me certainly to hand over in a second to Justice Kirby to declare this open and officially launched, which I shall duly do. But I did want to also move a vote of thanks to everyone who participated as well. All of the panelists who joined us, Jeannie, Graham, Julian, Justice Kirby for joining as well, and certainly also to Francis Gurry from joining us from Geneva. I did earlier on encourage people to have a drink. I obviously note that it's very early in your day, so whilst it's socially acceptable here in Sydney, I know that's pushing it, but certainly at the end of the day today, please, Francis, join us in celebrating the launch of this at a national stage, and thank you so much for joining us. Look, I think the themes, I always am very reticent after such an eminent panel wrapping up and summarising, but I think there was a strong theme of evolution, which is that we are looking back, as I said, with that Māori whakatauki, that phrase, walking backwards into the future when we reflect on Justice Kirby's remarks, and certainly the remarks from people like Graham and Julian and others who joined us. We are cognizant of history and the lessons we've learned about how multilateralism might work, to channel Francis's words, but also the challenge for all of us, which is to actually step up and to make our voices heard. I think all of you in your own way are doing this. You've done it on Slido tonight. You were doing it by joining us. You were doing it in your own capacities, in your professional capacities, in your capacities in terms of advocacy, and I encourage you to continue that. And there was that question early on in the evening from a young person, how do I get involved? Please do join. Note that the fees have been flagged for this year as well, so it is now your opportunity to become professionally affiliated and to join and to contribute. And I'm sure to some of the questions we had around the panel and who's here tonight, in decades to come, you will be looking back in the rearview mirror as well, as some of our panelists have been doing, but still very much in the driving seat. So I want to thank everyone for joining us. And without further ado, I'll hand over to Justice Kirby to officially declare the society launched, and I will leave you there. Thanks for joining us. Thanks for your engagement and for your serious questions too.
I have much pleasure in launching the Australian Society of Computers and the Law. I think this has been an excellent, much better than I expected actually. It's been a very good and practical dialogue. I'll give one word to the people who've taken part in the panel. To Jed Horner, I give the word join, because that's what he urged everyone to do, but positive, to think positively and not to think negatively about this amazing technology and its social implications. To Graham Greenleaf, I'll give the word AUSCL. It should have been mentioned by all of us. You are a hero of the legal profession in Australia and in the region and in the world, AUSCL and what it's done. But a lot of the people who are supporting this society are not supporting AUSCL where they should, with money. And I think this is something that should definitely be done. Julian, he said human beings do stuff. And he was a little bit pessimistic at first, unlike an advocate to be pessimistic, but he came round to seeing the positive aspects of Australia, and he has contributed greatly to them. Ginni Patterson, technology is not a one-stop shop. This is a multiple operation, and we've got to have a lot of activities and we've got to start planning for them now. And Francis Gurry, I have to say, for all Australians, we're very proud of you and how you've held a high office in the United Nations and how you have spoken up tonight for the principle of multilateralism and reminded us to be true to that principle and to be true to something which is important to law in Australia, process. And so with those words in mind, and thanking you, Jed, once again for your work as a convener tonight, I launch the Australian Society of Computers and the Law. May it succeed mightily.
Thank you kindly. And on that note, future focused, we have a few events which are about to appear soon. Upcoming seminars and speakers. So you can see there already, you are spoiled for choice. People who are engaged in society to begin with. And then we have a range of speakers coming up as well on a range of topics. I can see Beth Paterson there. Fantastic to see you again. Aurelie, who I work with. Wonderful. Michael, Kirby, you are just spoiled. You have the most amazing people in your orbit. And to Michael Kirby's words, get involved and join, please. We need your contributions. So here are a few of the upcoming seminars. AI, IP and geopolitics. My Lord, what a great topic. Good timing. And cybersecurity, again, couldn't be more timely. I'll forego my own. Fantastic topics to get involved with. Global topics, not just local. To the question we had on Slido about we need a global society, you already have one. And I think the talent's here in Australia. And that's us. There's a few coming up, but do visit the website as well. And obviously the slogan is be inspired, reconnect and reimagine. And I think that's happened tonight already. So I'll leave you all there on this note. Thank you so much for joining us. Thank you to the panelists, to the speakers, and most importantly to Marina, who did a tireless job in pulling this together. Marina, I tip my hat to you. Thank you for your leadership. I'll leave you all on that note. Take care. Mā te wā to the people in New Zealand. Good evening.